The heavy steel doors of a holding cell just slammed shut on a legal defense team inside a federal courthouse. And I'm not speaking metaphorically, this is literal. U.S. Marshals forcibly escorted multiple defense attorneys out of Judge Sarah Caldwell's courtroom and marched them straight into detention cells. Witnesses are describing it as the most volatile judicial showdown seen in decades. Remember, these weren't the defendants on trial, they were the lawyers, and right now they are sitting behind bars. Judge Caldwell didn't hesitate. There was no negotiation, no final warning. She dropped the order, the marshals swarmed in, and in a matter of minutes, the attorneys who entered that room to defend a client were hauled out in custody. When a federal judge throws the defense counsel in jail in the middle of a trial, you know we have crossed into catastrophic territory. So what sparked this historic judicial crackdown? It was a direct, calculated, and relentless campaign of insubordination against orders Judge Caldwell had issued repeatedly over the last few weeks. We aren't talking about a heated objection or a lawyer getting carried away in the heat of battle. This was a systematic attempt to sabotage federal proceedings, culminating in what prosecutors are labeling the most shameful display of contempt ever seen in a federal court. I've got the court filings, the eyewitness testimonies, and the judicial order right here. This 18-page document is brutal. Judge Caldwell dissects with forensic detail every violation, every caution, and every lifeline she threw to this defense team to get back on track. They didn't just ignore her, they doubled down. According to sources inside the room, after the final warning, the lead attorney looked Judge Caldwell dead in the eye and said something that made the entire gallery gasp. What followed is going to change how lawyers behave in federal courtrooms for a generation. Let's look at the hard evidence. The 18-page contempt order lists 17 separate acts of what Judge Caldwell calls willful and calculated defiance. It started 3 weeks ago. Judge Caldwell issued a strict pretrial order banning specific prejudicial evidence. What did the defense do? They brought it up 3 times in their opening statement alone. The judge immediately hauled them to the bench. The transcript is crystal clear. She said, "Counsel, consider yourself warned. Mention this excluded material one more time, and I will hold you in contempt. Do you understand?" Lead attorney Marcus Renert replied, "Understood, Your Honor." The very next day, he dropped the reference again, right in front of the jury. But here is the shocker. When Caldwell pulled him into a sidebar, Renert allegedly told her, and I'm quoting the filing, "Your Honor, with respect, I believe your ruling is wrong, and I intend to appeal. Until then, I'm running my client's defense my way." A prosecutor in the room said Judge Caldwell's face went stone cold. She didn't explode. She went back to the bench, told the jury to ignore the comment, and formally logged her first contempt warning. That should have been the end of it. Instead, the defense went rogue. Over the next 11 days, Renert and his 2 associates engaged in what the judge cataloged as an intensifying pattern of rebellion. They talked over her, they addressed the jury after being told to shut up, and they refiled motions that had already been denied 3 times. On day 14, Renert refused to yield the floor when an objection was sustained. He kept talking for 40 seconds while the judge ordered him to stop. The court reporter had to read back the record. The record will reflect counsel continued speaking over the court 6 separate times. Then came the nuclear option. During routine testimony, the defense flashed an exhibit that had been explicitly banned that very morning. When the prosecution objected, Renert turned to the jury and said, "Ladies and gentlemen, the court is hiding this from you, but I believe you deserve the truth." That was it. Judge Caldwell slammed the gavel. Recess. When the doors opened 45 minutes later, 4 U.S. Marshals were stationed behind the defense table. Judge Caldwell read an 8-minute statement, citing every failure to comply. Then she delivered the line that is now shaking the legal world. "Counsel, you have left this court no alternative. You are held in criminal contempt. Marshals, remove the defense." Handcuffs clicked onto wrists right there at the counsel table, in front of the jury, the client, and the public. They were processed like common criminals and held for 6 hours before bail was set. The context: hit that subscribe button right now because this situation is moving fast and the legal fallout is going to be massive. You don't want to miss the updates. Now you know what happened, but you need to know why. The defendant is Raymond Voss, a former top aide to a major political figure, facing charges of wire fraud and obstruction. The case was a powder keg from day one. The defense strategy seemed less about winning on facts and more about turning the courtroom into a political circus. When Judge Caldwell, a strict George W. Bush appointee, got the case, the defense panicked. They tried to get her recused, denied. They appealed, denied. Legal analysts believe their strategy then shifted to manufacturing error. The goal? Make the trial so chaotic that no conviction could survive an appeal. Judge Caldwell saw the trap. She stated on the record weeks ago, "I will not be baited. I will not be provoked. I will not let this courtroom become a circus." The defense responded by testing her limits every single day. By the third week, she had already fined Renert $45,000 for civil contempt. He paid the cash and kept breaking the rules. That's when Caldwell realized fines weren't enough. She had to make a move that would define her legacy. Smash that like button if you're following along. It helps get this truth out there. After the arrest, the scene was surreal. Renert had smiled at the Marshals when they first walked in. 5 minutes later, in handcuffs, he wasn't smiling. This isn't just about contempt. This is about a federal judge drawing a line in the sand. Legal experts are calling it a masterpiece of judicial strategy. Professor Jonathan Turley noted that by documenting every single violation in that 18-page order, Caldwell created a bulletproof record. She didn't lose her temper, she laid a trap, and the defense walked right into it. Ellie Honig from CNN pointed out the reality. This isn't a slap on the wrist. These lawyers are facing real prison time, and the image of attorneys in cuffs, that sends a message to every lawyer in America. You can push, but you cannot break the court. The fallout. So, what happens now? The attorneys. Renert and his team face criminal charges and likely disbarment. A 30-year career could end in disgraced ruin. The trial. Mistrial declared. Prosecutors will retry Voss, but the new defense will claim the jury pool is tainted by this spectacle. The defiance. Upon release, Renert held a press conference calling Judge Caldwell a tyrant and the arrest political theater. Legal ethics experts say this was a fatal mistake. Instead of apologizing, he attacked the judge. Every word he said will be used against him at sentencing. This was a gamble. Marcus Renert bet that no judge would actually lock him up. He was wrong. Judge Caldwell proved that the courtroom is not a stage for political games. It is a place of law, and when you cross the line, the consequences are real. Subscribe and hit the bell. The sentencing hearing is next month, the appeals are being filed, and I will be here breaking down every single moment. This is a reckoning. Don't miss it.